Good evening, ladies and gentlemen. Thank you all for being here today. My name is Kartini and I'm a case counsel with the AIAC. I'm pleased to welcome all of you here today to our evening talk series entitled Res Judicata in Arbitration. Today's evening talk will run from now until 6:45 p.m., starting with Leng Sun's presentation from 5:30 to 6:30, followed by a 15-minute Q&A session. After that, we shall conclude our evening talk with a networking session. Let us kickstart the evening by introducing you to our speaker for today's session, Mr. Leng Sun. Leng Sun is a senior counsel of the Supreme Court of Singapore and a chartered arbitrator practicing with the Duxton Hill Chambers. He's a member of the Singapore International Arbitration Centre and the ICC Commission on Arbitration and ADR. He's formerly the global head of arbitration of an international law firm and president of the Singapore Institute of Arbitrators. He's the deputy chairman of the SGX Appeals Board and qualified in Malaysia, Singapore, and England. He has a broad commercial practice and has acted as a counsel or sat as an arbitrator in arbitration seated in Asia, Europe, and the United States of America under ad hoc and institutional rules. Leng Sun has also served as a legal officer in the United Nations Compensation Commission in Geneva and is the author of a book, Singapore Law and Arbitral Awards, and co-editor of Conflict of Laws in Arbitration. He is recognized among the top lawyers worldwide by legal directories such as Who's Who Thought Leaders, Litigation 2022, Who's Who Legal, Arbitration 2022, and Akrita Stars 2021. He is described by WWL as being among the very best dispute lawyers in the world and lauded as one of ALB Asia's Super 50 dispute lawyers, which reported him to be spectacular, with exceptional knowledge and depth of insight. Without further ado, I would like to pass the floor to Leng Sun to get started with his presentation today. Leng Sun, the floor is yours.
Thank you very much, Katsumi. Good afternoon to all of you. I'm really grateful that AIAC is organizing this event so that I have a chance to see some of my friends again in person. It's been too long, and I'm doubly grateful to all of you for coming here on a Friday evening. After a hard day's work, or in fact a hard week at work, probably you wouldn't want to be faced with another lengthy and heavy topic like res judicata. But then again, maybe before you break for your Friday evening's margarita, you do need to listen to me speak about res judicata. As they say, no pain, no gain. Right. Now, to understand how res judicata operates in the field of international arbitration, we need to first see how the doctrine is developed in courts and by the courts. So my topic today really is not so much about the finer points of res judicata as they are dealt with under Malaysian law, Singapore law, English law, although I will have to explain the root of these concepts and the different principles that apply under res judicata. But I do so purely for the purpose of the topic, and that is to demonstrate how some of these principles can be transposed to international arbitration, where the subject becomes rather more complicated. It is probably complicated enough when you're dealing with it in the domestic court setting, although the principles have been refined over the years, so we kind of know what they are. But it does become a little harder to grapple with once you bring it to an international setting, especially in the setting of international arbitration. So what I will do first is to start with talking about res judicata as it is developed in court. I'll be happy to share the slides with you after the event through AIAC, so you don't have to like take a photograph of the screen or anything like that, okay, to make it easier for you. Right. Res judicata is a concept that is well recognized in many jurisdictions. You might even say that it is part of public international law, and it is actually recognized as a general principle of law recognized by civilized nations. And that's the test for one of the limbs of public international law under Article 38 of the Statute of the International Court of Justice. So it is widely practiced, widely recognized in all jurisdictions. Res judicata in Latin actually means a thing adjudicated. Okay? But in some other countries, probably say civil law countries, they may not call it res judicata. They may describe it as claims preclusion or issue preclusion, but basically the same idea that what has been decided in an earlier adjudication is binding and cannot be repeated or reopened in subsequent proceedings between the same parties. The contents of the rule vary country by country. Most common law countries have adopted a broad rule which encompasses not only cause of action estoppel, okay, I will talk about these concepts in a while, but also issue estoppel. Okay, they are all under the umbrella of res judicata. Moreover, many common law countries have an extended doctrine of res judicata to preclude the raising of arguments which could have been raised but were not raised in the earlier proceedings. And this extended doctrine of res judicata is grounded in the broader procedural concept of abuse of process. For the purpose of this talk this afternoon, I'm taking pains to draw the distinction between this abuse of process doctrine of extended res judicata, or what you'll hear being described as the Henderson against Henderson rule, the rule in Henderson, and the traditional or conventional concepts of res judicata known as cause of action estoppel and issue estoppel. Okay. Civil law countries like Germany, France, Switzerland, China, Japan, and Korea have a more limited scope of res judicata. This more limited doctrine in the civil law countries covers claim preclusion, meaning cause of action estoppel, but not always issue preclusion, otherwise known as issue estoppel. But there are some countries, civil law countries like France and Spain, which have developed an extension of the cause of action estoppel to cover issue estoppel. And they call this principle of concentration. Okay. The topic can get pretty confusing and hard to manage if I jump about to talk about different countries, because then you don't have an anchor on the principles. So what I'm going to do this evening is really to focus on res judicata as it is developed in England, Singapore, and Malaysia. Let me see where we are. Okay. And to start off with an explanation of res judicata in these countries, I would really recommend these two leading cases from the Singapore courts. One is the High Court decision of Judicial Commissioner Sundaresh Menon, as he then was, in Go Nelly against Golian Teck. And then the next one is again his decision, this time as Chief Justice, in the Court of Appeal decision in the Royal Bank of Scotland against TT International. And from these two principles of two cases, you will find a very nice articulation of the three limbs of res judicata. Okay. And these three limbs are as follows. First of all, as I mentioned, cause of action estoppel. What is cause of action estoppel? It is a principle that prevents a party from asserting or denying a cause of action which has been determined by a court of competent jurisdiction in previous litigation between the same parties. And this bar is absolute unless there's fraud or collusion. The next limb of res judicata is issue estoppel. And that precludes relitigation of an issue in subsequent proceedings if a court has already determined that issue as an essential step in its reasoning leading to its decision. To give rise to issue estoppel, that previous determination must have been fundamental and not merely collateral to the previous decision. So the decision could not stand without that determination. That's the test for issue estoppel. Now there is, and I mentioned this even though I said I'm not going to go into all the final points, but this exception called the Arnold exception comes up quite frequently in discussions. So I might as well mention it very briefly. The House of Lords decision in Arnold against National Westminster Bank has given rise to an exception to issue estoppel on the basis that, well, some judges have said that it's a wide discretion given to the court to avoid injustice by declining to apply issue estoppel if there were reasons why the material argument was not raised in the previous litigation. The Singapore Court of Appeal has declined to apply a broad exception of the Arnold exception. They narrow it down and say we should not be applying such a broad discretionary power to undermine the idea of finality in litigation and to undermine the operation of issue estoppel. So where the Singapore court is concerned, the Arnold exception is limited to a situation where the previous decision is clearly wrong, okay, because of some point of fact or law relevant to the decision that was not argued and could not have been argued with reasonable diligence. So they apply a stricter test. And finally, we come to the third limb that I had mentioned, and that's abuse of process, or the extended doctrine of res judicata. This last principle is referred to as the rule in Henderson against Henderson. And what it means is that the court will not permit issues to be raised if they could have been but were not raised in an earlier action, either deliberately or due to negligence or inadvertence. Abuse of process is a broader, more flexible inquiry, and one considers all the circumstances of the case, including whether there's fresh evidence that might warrant re-litigation, or whether there are bona fide reasons why a matter was not raised in earlier proceedings. In this regard, the court does not adopt a rigid or inflexible attitude to abuse of process. I will refer to cause of action estoppel and issue estoppel as conventional res judicata. The Singapore courts refer to them as strict res judicata. Okay, but it doesn't matter, it's just nomenclature. Whereas the abuse of process doctrine, I can describe as the Henderson rule. Okay? And these are principles primarily developed to deal with res judicata arising from another court's decision in the same jurisdiction. Okay? In other words, domestic res judicata. But this is not to say that these principles or res judicata do not apply to foreign court judgments. They do, and they have been applied. But as we will see towards the end of this talk, there are additional considerations when one is dealing with what we shall call transnational res judicata. What about Malaysia? A quick search that I did on Lexis throws up 3,000 hits on res judicata in the Malaysian courts. All right. Obviously, I didn't cover 3,000 cases. So those experts among you on Malaysian law will forgive me and maybe correct me later if I have overlooked any crucial or critical authority from Malaysia. The doctrine of res judicata in Malaysia is similar. It also encompasses these three limbs: cause of action estoppel, issue estoppel, and Henderson rule. Okay. But there is a question that might come up because of the way that a federal court decision had described the Henderson rule in the past. And this is the leading federal court judgment in Asia Commercial Finance against Kawal Teliti. Federal FCJ, Federal Court Judge Pei Sui Chin, said in that case, and I quote, "In order to prevent multiplicity of action, such estoppel of cause of action has been extended to all causes of action based on the same facts or issues, which should have been litigated or asserted in the original earlier action resulting in the final judgment, and which were not, either deliberately or due to inadvertence." Elsewhere, FCJ Pei said he preferred the broader approach to the scope of issue estoppel. That issue estoppel applies to issues which might have been and which were not brought forward, either deliberately or due to negligence or inadvertence. So from the way that the principles were expressed, you might think that the Henderson rule is subsumed within the principle of cause of action estoppel or issue estoppel, but I don't think that was the intention. My view is that the position in Malaysia is not substantively different from that in Singapore or England, in that it recognizes these three limbs. And Asia Commercial Finance did not clearly articulate the Henderson rule as a separate and distinct limb because there was no reason to do so. The question didn't arise on the facts of that case. But if you look at Malaysian cases on res judicata, they invariably cite English cases where the Henderson rule was discussed and explained. One example is the Malaysian Court of Appeal judgment in Man Holdings against Ang Yok Hong, okay, where Justice of the Court of Appeal, JCA, Mary Lim, recognized the doctrine of abuse of process as a closely related but separate principle from the doctrine of res judicata. In Muhammad Nur Hafiz bin Roslan against Muhammad Izani bin Muhammad Jakil, okay, Judicial Commissioner Muhammad Arif Emran Arifin clearly dealt with the ingredients of the Henderson rule, abuse of process, as a separate ground from conventional res judicata. In doing so, he cited an off-cited judgment of Lord Sumption in Virgin Atlantic Airways against Georgia Seats. Now, I'm taking some time to cite to you what Lord Sumption has said in Virgin Atlantic, because as I will explain, the question of the Henderson rule becomes a more interesting one when you talk about arbitration. So to quote Lord Sumption, the principle in Henderson and Henderson has always been thought to be directed against the abuse of process involved in seeking to raise in subsequent litigation points which could and should have been raised before. Henderson against Henderson abuse of process as now understood, although separate and distinct from cause of action estoppel and issue estoppel, has much in common with them. The underlying public interest is the same, that there should be finality in litigation and that a party should not be twice vexed in the same matter. Res judicata and abuse of process are juridically very different. Res judicata is a rule of substantive law, while abuse of process is a concept which informs the exercise of the court's procedural powers. In my view, they are distinct, although overlapping legal principles with a common underlying purpose of limiting abusive and duplicative litigation. So why do we care how we describe the Henderson rule, whether as an abuse of process rooted in the court's procedural powers or as a rule of substantive law? This distinction has not mattered very much when the question comes up in court. But in international arbitration, when you have usually conflicts of laws questions coming up, it can become quite important. So that brings us to the question of how res judicata is applied in arbitration. Professor Gary Bond acknowledges that despite widespread acceptance of the res judicata effect of an award, there is limited agreement on the precise preclusion rules that apply to international awards. He submits, however, that it is inherent in the nature of an agreement to arbitrate and the concept of an arbitral award based on Article 3 of the New York Convention that such an award will have binding and thus preclusive effects. Now, the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards is about, as the name suggests, recognition and enforcement of awards by national courts. So the starting point is that courts will recognize and enforce arbitral awards. And here Article 3 of the New York Convention says this: each contracting state shall recognize arbitral awards as binding and enforce them in accordance with the rules of procedure of the territory where the award is relied upon. It's important to bear in mind for our purpose that the New York Convention speaks not just of enforcement, but also recognition. Okay? This includes not just enforcement of the award by the successful party seizing the assets, for example, of the losing party, but also reliance on the award to defend or set off any contrary claims by the losing party in subsequent proceedings. Recognition is particularly useful when the award contains declaratory pronouncements on the rights and obligations of parties. But where do we go beyond the New York Convention? National courts have recognized that res judicata can apply to decisions of arbitral tribunals. And this includes their standard doctrine or the Henderson Rule. Starting first with a decision, another important decision of the Singapore Court of Appeal delivered by Chief Justice Menon, AKN against ALC. He says this: just as finality is of significance to the courts, so too is it of importance to arbitration. Thus, the courts will not typically rehear matters that have already been determined in arbitration. Further, the court may disallow a party to raise certain points in court which it could and should have raised in arbitration. In other words, as the court says, their standard doctrine of res judicata, which derives from Henderson and Henderson, has been acknowledged in Singapore to be part of the doctrine of abuse of process. So I pause here to say, of course, if an award has been set aside, it's been rendered invalid, it will not create any res judicata. In AKN, for example, the court says where an award was set aside because the tribunal overlooked the merits of one party's submissions and never dealt with the merits, there is neither strict nor extended res judicata. The parties are free to commence fresh arbitration proceedings before a new tribunal. Now we come back to Malaysia. The Malaysian courts have also applied the Henderson Rule to arbitration. Here I thank Kartini and the AIC for bringing to my attention the case of Orient Energy Investments against the owners of the ship Cavalier. To give a very, very short summary, in that case, Judicial Commissioner Aslan Sulaiman held that the defendant ship owner in a Malaysian in rem action was stopped from arguing that an arbitration clause in a fixture note was incorporated into the bill of lading contract, upon which the plaintiff shipper had sued in Malaysia. Okay, that's quite a mouthful. Let me break it down, especially for those who are not shipping lawyers. What happened is that the plaintiff shipper had sued on a bill of lading contract in Malaysia and arrested the ship in an in rem action. Prior to that, the ship owner had actually commenced arbitration in London based on what the ship owner claims to be a fixture note or charter party between the ship owner and the shipper and another party. But the shipper challenged that arbitration on the basis that it wasn't a contracting party to that fixture note. And the London Tribunal agreed and dismissed the arbitration. So when the defendant ship owner now in Malaysia argues again that there was a fixture note with an arbitration clause, a different fixture note containing an arbitration clause, and the arbitration clause had been incorporated in bill of lading. And on that basis, the ship owner then tried to stay the Malaysian action for arbitration. The shipper then argued, well, maybe you didn't argue this point exactly, but you could have argued it, right? You brought an arbitration on the back of a charter party fixture note, which failed, but you could have argued that, alternatively, there was another fixture note with an arbitration clause that applied, and you could have relied on that. So the court in that case agreed with the shipper and said that this was a point that the defendant ship owner could have raised and should have raised in the London arbitration. And on the Henderson Rule, the Tribunal was stopped from arguing that point in the Malaysian action. Singapore and Malaysia's position on the application of the Henderson Rule to arbitration finds support in the work of the International Law Association, ILA. The chairman of the committee, Professor Philip Daly, and the rapporteur, Audley Shepherd, released this report, the ILA recommendations on dependence and res judicata and arbitration, and recommended as follows, I quote, "An arbitral award has preclusive effects in the further arbitral proceedings as to a claim, cause of action, or issue of fact or law, which could have been raised but was not in the proceedings, resulting in that award, provided that the raising of any such new claim, cause of action, or new issue of fact or law amounts to procedural unfairness or abuse." So it was a recommendation on the principle to be adopted in arbitration. But then these are recommendations, all right? They are not law. Now we come to the harder question. If an arbitral tribunal is applying res judicata, right? Notwithstanding the IOS recommendation, as we have seen, while there might be uniformity on the rules of res judicata in a few common law countries, there's no global uniformity on the contents of the doctrine. Hence, the question of which law on res judicata applies can become rather acute in international arbitration. Bernard Hanutiel, for example, submits that the lex arbitri should determine res judicata rules because it is the juridical home of the arbitration. Okay, what does lex arbitri means? Let me backstep a little bit. In an international arbitration, there could be different laws applying on different matters. First of all, you have the substantive law of the dispute, what we call the lex causae, the law of the cause, okay, which will usually be the governing law of the contract, which is in dispute. So that's the substantive law, lex causae. Then you also have the law of the place or the seat of arbitration, the lex arbitri, which is loosely known as the arbitration law. Okay, and that would usually be based on the law of the seat. So in if you have an arbitration here in AIC seated in Kuala Lumpur, it will be Malaysian Arbitration Act applying. So what Bernard Hanutiel says is that the lex arbitri should determine res judicata rules. And he cites a number of ICC awards and reports and opinions of juries in support of this view. Then there's another view by David Williams and Mark Tushenham, who say that the English position supports characterizing res judicata, including extended res judicata, as a substantive rule governed by the lex causae. Now, I personally doubt that the English position is so clear that even extended res judicata or Henderson rule is a substantive rule. Okay. The better view, as you will hear very shortly, is that conventional res judicata is a substantive rule, matter of substance, that is cause of action estoppel and issue estoppel. But for extended res judicata or the Henderson rule, that's part of the procedural law of the lex arbitri. Courts have seldom troubled themselves with this question. Okay? That's why you hardly see that point being discussed in Malaysian case law, despite the 3,000 hits. Now, again, I haven't gone through 3,000 cases. Maybe you'll find one that discusses it. All right. But a recent judgment of the Singapore International Commercial Court, rendered just 2 weeks ago on 1st of June, highlights the finding of an arbitral tribunal, which made this very distinction between issue estoppel as a rule of substantive law and the Henderson rule as a procedural rule of the lex arbitri. And that case is Sanlam Investments against Government of the Lao People's Democratic Republic. Okay, this is a long-running dispute that has generated many many cases and judgments. But in this particular dispute, okay, the relevant facts are this. There's a previous SIAC tribunal in SIAC arbitration number 143, okay, that had rendered an award in favor of the Lao government against the investors, Sannom and Lao Holdings. Okay, I'll call them the investors. So Sannom and Lao Holdings are the investors. And then there was an award against them in favor of the Lao government. Subsequently, the investors brought another arbitration, SIAC arbitration number 414, against two corporations. For short, they are known as SM and GAS. Okay, SM and GAS. The Lao government applied to be joined as a co-respondent and was joined, even though the claim wasn't brought against the Lao government. This arbitration 414 tribunal dismissed the investors' claims against SM and GAS, partly based on a finding that the investors were stopped from raising some claims due to the earlier 143 award in favor of the Lao government. And the 414 tribunal made this finding based on New York law on collateral estoppel as a substantive rule of law. So this tribunal had applied New York law as a substantive law on collateral estoppel. Now, collateral estoppel under New York law is similar to issue estoppel under English law. It prevents relitigation of an issue of law or fact that was raised, litigated, and actually decided by a judgment in prior proceedings between the parties, regardless whether or not the two proceedings are based on the same claim. The tribunal finds that the New York doctrine of collateral estoppel applied to preclude the investors from arguing the merits of the claims that were found to be estopped. And this was so even if SM and GAS were not parties to the prior SIAC arbitration. They were found to be privy with the government of Laos for the purpose of the collateral estoppel doctrine. Now, interestingly enough, the same tribunal considered an argument of abuse of process of Henderson Rule, and the tribunal found that the Henderson Rule was a procedural doctrine under Singapore law as the lex arbitri. And they considered the Henderson Rule under the procedural law of Singapore. But they found the rule didn't apply on the facts of that case because one of the conditions for the application of that Henderson Rule, that is, that issue or claim could have been brought in the earlier proceedings, was not satisfied. So this tribunal was quite clear on the distinction between issue estoppel or collateral estoppel under New York law and the Henderson Rule under Singapore law. So the investors applied to set aside this award, claiming that there had been a breach of natural justice because the tribunal, by stopping them from bringing the claim, did not give them a chance to be heard or a chance to present their case. They also argued that the award was contrary to the public policy of Singapore, which required access to justice. Okay. This was rejected by the SICC, and they found that there was no breach of natural justice or breach of public policy just because the tribunal had applied res judicata, because that was part of the job of the tribunal to determine whether any claims are precluded by res judicata. And you can't say that there was a denial of justice just because the tribunal made that finding. A number of Singapore and English decisions or cases have actually supported this distinction that I mentioned, that the Henderson Rule is governed by the lex arbitri as a matter of procedural law. Okay. As you may recall, when I cited the Royal Bank of Scotland and then AKN against AKC, Chief Justice Menon had emphasized that the Henderson Rule is part of the abuse of process concept, and that's a procedural law. Then a full quorum of 5 in the Singapore Court of Appeal judgment in BWG against BWF also treated the Henderson Rule as a category of abuse of process doctrine. And this quorum of 5 further pointed out that the abuse of process doctrine coheres better with the whole law of civil procedure. A number of Singapore cases have also applied this extended doctrine. For example, the ultra polis case, the Denmark case with a very long name that I can't pronounce, I'll call it the ultra polis case, where Justice Quentin Low applied the Henderson rule to preclude the respondent from bringing a cross claim that it could have but did not bring in the Danish arbitration. So an award was made in Denmark, applying Danish law, being the law governing the agreement, and the claimant that then used that award as a basis to bring winding up proceedings in Singapore. When winding up proceedings were brought in Singapore, the respondent then tried to bring a cross claim. But Justice Quentin Low, following the English court's decision in Dalal and Bang Melak, applied the Henderson rule and said, no, you could have brought that cross claim in Denmark, but you didn't. So you can't bring that now in Singapore. Therefore, the position adopted by the tribunal and a number of the Singapore cases seem to suggest as follows. In relation to an arbitration where the governing law of the contract is, say, Japanese law, but the seat of the arbitration is, say, Kuala Lumpur, any question regarding cause of action estoppel or issue estoppel will be determined by Japanese law in the lex causa. But any question on the application of the Henderson rule will be determined by Malaysian law as the lex arbitri. What then is the effect of the tribunal's ruling on res judicata? It has been decided in Singapore that the tribunal's ruling on res judicata is a ruling on the admissibility of a claim or a ruling on a question of law. It is not a ruling on jurisdiction. Why does that matter? For those of you who are familiar with arbitration and challenges to awards, you know that one of the grounds to challenge an award is that the tribunal had no jurisdiction. And even if a tribunal makes a ruling on jurisdiction, that ruling on jurisdiction doesn't bind the court because the court will have the final say on jurisdiction. So in BTN against BTP at the High Court level, Justice Belinda Ang found that res judicata is a question of admissibility, and therefore the dissatisfied party couldn't go to the court and say, I want to set aside this award or finding because the tribunal made a wrong ruling that affected its jurisdiction. And Justice Belinda Ang said, no, it's a question of admissibility of a claim, which is no different from any other finding, whether of fact or law, and you can't set aside an award on that basis. And this was endorsed by the Court of Appeal in the same case, BTN against BTP, where they say that even an erroneous ruling of res judicata would not found a challenge to the award on the basis of public policy. And such errors are not to be treated any differently from other errors that the tribunal might make on the merits of the case before it. This was followed by the SICC in the Sannom case, citing BTN against BTP, and I quote the SICC. It can be seen then that the tribunal made determinations of law and fact in relation to a doctrine of substantive law under the governing law, namely New York law. Right? You may recall that the question there was collateral estoppel under New York law. It was these determinations that in turn led to the conclusion that the doctrine of collateral estoppel applied so as to preclude the investors from arguing the merits of their estopped claims. This is very different from a tribunal mistaking its procedural powers or the scope of issues in play before it, and on the basis of such a mistake, either proceeding to an award without hearing one party or excluding evidence wrongly. It is instead the tribunal doing what it was tasked to do, namely to determine the dispute referred to it, including determining the application of any preclusionary or exclusionary doctrines raised by a party before it. Whether the tribunal made an error of law or fact in its decision that the doctrine of collateral estoppel applied goes only to merits and cannot found a challenge to the award. Okay. So far, I think so good. I hope people are following. And good things cannot last, so I'm going to now go on to a difficult question that I have no answer to. Okay. And this is a question: to what extent are arbitral tribunals restricted by the doctrine of res judicata when faced with previous national court judgments? At the beginning of this lecture, when I explained the three limbs of res judicata and the principles, I said that, well, these are the principles developed by national courts, and you don't have a problem with that when you're dealing with previous decisions of the courts from the same jurisdiction. Now, of course, we have seen many cases where these principles have been applied to foreign court judgments, and quite correctly so. I'm not saying that they shouldn't apply, but there are times when you find certain scenarios that give rise to further questions, and you ask yourself, is it right that there should be res judicata in this case? Okay, and these were some of the questions that were raised by the Singapore Court of Appeal. Oops, I don't have the citation here. Okay, in Merck Sharp against and Dompt against Merck KGAA. Okay, but don't worry, that citation or that case will be given to you when the slides are circulated. Okay, in the Merck case, the Court of Appeal explained that while the elements of issue estoppel apply to a prior foreign judgment, just as they do to a prior domestic judgment, additional considerations come into play in transnational issue estoppel. For example, where there are multiple competing foreign judgments, the first in time should be recognized. But a local judgment will prevail over a foreign judgment. But that's not the end of it, because however, the court will be open to the possibility of taking into account any litigation taken purely as a preemptive step, taken with undue haste, just to preempt recognition of a prior foreign judgment. The Court of Appeal also calls for common law to be developed such that there is convergence between common law and statutes, such as the CCAA, the Hague Convention on Choice of Court Agreements Act, and the Reciprocal Enforcement of Foreign Judgment Act, on the defenses against recognition of foreign judgments. The bottom line is that the clearly delineated principles that we have seen on the three types of res judicata in judgments such as Gormley and Royal Bank of Scotland are not the final word on transnational res judicata. This is an area that's still developing, and in fact, the language of the Court of Appeal in the Merck case was rather tentative. It was just observing that there are many considerations that the court might have to take into account, because when you're dealing with forum shopping, for example, there are so many scenarios that can arise which may create injustice if you blindly apply res judicata. In a similar but more challenging vein, how should an arbitral tribunal treat a prior national court's decision on the subject matter raised in arbitration? First, the tribunal has to decide on the choice of law to apply on res judicata. It would apply, for example, the governing law of the contract or substantive law if it's considering conventional res judicata, cause of action estoppel or issue estoppel. Or you might apply the law of the seat, lex arbitrii, if it's considering the abuse of process or Henderson rule. But secondly, and this is a conundrum, should it apply the same test for res judicata developed by the courts? Bear in mind that the tribunal may have considerations other than fraud or the Arnold exception when it's considering a prior national court's judgment in the context of arbitration. For example, what if the previous national court judgments had ignored an arbitration agreement? frequently happens that one party may go forum shopping in violation of the agreement to arbitrate. And we have seen many instances where, notwithstanding a valid ongoing arbitration, one party may just go to his home court to secure an advantage, to get some order or some judgment, a favorable judgment, right? So what is an arbitral tribunal to do when faced with this? And what about multiple and conflicting judicial decisions? So you see that those simple and straightforward rules that I had articulated at the beginning do not seem to be quite sufficient or adequate to deal with some of these scenarios. The ILA final report that you have been reading while I was speaking, okay, does recognize that. It says, and if I quote, however, international arbitrators may be faced with res judicata problems, not only in relation to prior arbitral awards, but also in relation to prior state court judgments, specifically regarding the existence of an arbitration agreement. Where a prior state judgment is invoked in arbitral proceedings, arbitrators may have to determine the res judicata effects of the prior judgment. Since the recommendations do not deal with the relationship between state courts and arbitral tribunals, they will equally not apply to the question what the arbitral tribunal is to do when faced with a prior state judgment. Also, in this respect, arbitrators may consider that they should not automatically apply the res judicata doctrine of the law governing the previous state judgment and all of the arbitration seat, but take the recommendations into consideration. Now, don't get too hopeful. Although the report says take the recommendations into consideration, you will not find any recommendations in there that tell you or offer any suggestions on how to treat state court judgments. Okay. To conclude, I'll just make a few proposals that I think are not too controversial. First, there is res judicata arising from arbitral decisions. Secondly, it is relatively straightforward when a cause of action, estoppel, or an issue has been raised and determined in a prior arbitration. This will give rise to your conventional res judicata, cause of action estoppel, or issue estoppel. Thirdly, there's support for the view that the Henderson rule should also apply in arbitration, so that any issue or material that should have been raised in a prior arbitration but was not would also be precluded in a subsequent arbitration. But this is not a rule that has been developed in all jurisdictions. A question will arise which law will apply when one considers the Henderson rule. The better view is that it's the law of the seat, since that is a question equated with abuse of process, which is a procedural question. Fourthly, an arbitral tribunal's decision on res judicata is not a decision on jurisdiction. It is a decision of law or fact, or on admissibility of a claim or argument. Therefore, it is not a ground for setting aside under the ancestral model law or for refusing enforcement of the award under the New York Convention. And fifthly, finally, whether there's res judicata arising from a prior national court decision is a much harder question. One can see that there may be circumstances other than fraud why it would be unjust to preclude a claim or issue to be raised in arbitration. For example, if one party had gone forum shopping in disregard of the arbitration agreement. And that brings us to an end to the talk. I think there'll be questions and answers. I ask the question and hopefully you will provide the answers. Okay, thank you.